Thanks everyone for being here. It's my pleasure to join you today and talk about this topic. As Celie mentioned, I do intellectual property work as an attorney at Stoll Reeves. I've been doing that for a little over 10 years now. My focus has been on enforcement and defense, so disputes regarding intellectual property. I'm a licensed patent attorney as well as doing a lot of copyright and trademark work, so I see the full gamut of kinds of intellectual property, from brands to artwork to inventions. And so we'll focus on creative kinds of works today, since we're dealing with artists and that we're volunteer lawyers for the Arts Association. But feel free to ask questions about other kinds of intellectual property, and we'll actually touch on that some during the presentation, because when someone uses your work without permission, it doesn't really matter which intellectual property right they're violating. If you have one of them and they're using it without permission, then that's a way to monetize. And so we're going to try to get creative about how to make your creativity profitable. And so I'll speak broadly, and then we'll do some examples, and then we'll try to focus in the Q&A on even more specific questions that you all might have. So whoever is listening or listens to this recording at another time, you have your work. You're a creative, you're an artist, you make stuff with your hands, you write, you make music, you sing, you perform, you design, whatever it is that you do, it's part of you. And so when someone else does that same thing without your permission, they're kind of violating you. And the law, thankfully, gives some recognition of that. It's not an entire overlap with what you might feel would be morally just for someone taking a part of you, but there are some legal recourses. So if your illustrations show up in a Facebook ad or on a web store where someone's using your artwork to market their product, or using your artwork to market your product, but it's not actually your product, it's just identical, or merchandise, or someone makes a movie using your materials, all of those kinds of things can be forms of unauthorized use. And I'm probably preaching to the choir when I say this, but even when you've given permission to someone to use your work, if they use it outside the restrictions that you put on that authorization, that is also an unauthorized use. And so many times you'll see situations in the context of licensing where the licensee, so someone perhaps who you've given permission to use your work in a limited place and time, continues to use your work outside of those boundaries. And that's another form of unauthorized use. In which case, you may have a breach of contract claim under the license agreement, as well as, sort of garden variety intellectual property infringement. So one comment I want to make as we get into this, let me go back one slide, is that deciding what to do when someone uses your work without permission should start, and this isn't legal advice, this is just thinking like a human, should start with, what do you care about? And what do you want to achieve out of the situation? Sometimes the use is something you like, in which case what you want may be for that use to continue, except you get paid for it. Other times the use is offensive and you want them to stop, regardless of whether or not you get paid for it. And then other times the use is competing, and so they're diverting sales away from you, in which case, maybe you're okay with them continuing if they pay you what you would have made if you had made the same sales. And so each of those situations calls for a different approach. There's not a one size fits all. So the first question in deciding how to respond to use of your work without permission is what do you want to get out of it? Do you want to make them stop? Do you want to get paid, or some combination of the two? And then the next question is, how are you going to go about it? And that's where it helps to have options. So, and the sort of threshold of understanding what options you have is understanding what intellectual property rights you have under the law. And these are sort of the 5 big ones that I've got on the screen now: copyrights, trademarks, trade secrets, and 2 different kinds of patents: utility patents and design patents. Any given work of creativity or of artistry or of expression may have one or more of these intellectual property rights involved in it. The copyright and trademark are the ones we'll talk about the most today, because those exist independently of you having to do anything but be an artist. So copyrights arise upon creation of a work that's fixed in a tangible medium of expression. So it can't just be performing a dance, but once you record the dance, then it's fixed in a tangible medium like the recording tape or the digital video file, and is protected by copyright. Trademarks arise from use, essentially, of a brand, such that consumers in your market or in your geographic region recognize the mark as indicative of a single source of goods or services. And so that arises upon use. Now, registration helps. And so we'll talk about things you can do to improve your legal position under both copyright and trademark law. But you have those rights without doing anything but what you're already doing. Go to the next slide. So registration will enhance your remedies, and that's give you more options to monetize. We're not going to spend as much time on trade secrets. Those exist when you have a secret, and it requires you, the owner, to maintain reasonable efforts to keep it secret. But that's something we could talk about in the Q&A if folks have questions about that. Usually a non-disclosure agreement, password protection, some kind of other reasonable efforts to maintain secrecy are required. But you don't have to register trade secrets for them to exist. And patents, we can also touch on, require examination by the US Patent and Trademark Office. So there's a much higher threshold to clear in order to obtain a patent. And they also last the shortest amount of time. So we'll touch on those a little bit in some of the case examples. So digging in a little bit more deeply on the different options for monetizing. So you're looking at your work, you're looking at the unauthorized use of your work, you're asking yourself the question, what legal rights do I have? Let's think about copyright. Copyright infringement occurs when the exclusive rights of the copyright owner are violated. Those exclusive rights are to reproduce the work, to make derivative works, to distribute the work, to publicly perform the work in case of performance kinds of works, or display the work in the case of like visual arts. And in the case of sound recordings, to perform the work by digital audio transmission, such as streaming. So if the unauthorized use that you're dealing with is doing one of these things with your work, like someone's made a copy of it, and that could just be putting up a web shop, or posting an article online that has a copy of your work. That's a violation of the copyright owner's right to reproduce it. If they've made their own creative work with it that incorporates your work, that could be a derivative work. So also a violation of the copyright owner's exclusive right to make derivative works. If they've taken your work and shared it with others. So let's say, trying to think of a good example of this. If someone downloads a song that you shared on the internet, and you've posted a music video to YouTube, someone manages to capture that using a recording technology and then share it with others. Well, they've both copied your work in violation of your right to reproduce and distributed it. So it's 2 separate violations of the copyright owner's exclusive rights. So you start to get the idea of how copyright law, even though it doesn't prohibit others from using copyrighted works, the prohibitions and exclusive rights of the owner are quite extensive and cover almost every kind of use you could imagine. Trademark infringement occurs when somebody uses any mark. So a trademark can be almost any kind of symbol. The law recites a word, a term, a name, a symbol, a device. It can even include phrases like slogans in a manner that's likely to cause confusion as to the affiliation of one person with another or of the approval, sponsorship, or origin of one person's goods and services from another person. So this is really getting at the concept of branding, but branding in the very broad sense that if you use a slogan or a logo to designate your work or yourself as an artist and somebody else uses that without your permission, then you have a trademark, or sometimes it's referenced more broadly as a false advertising claim against that person. To have a copyright, I just want to make a couple notes on this as we're thinking through what intellectual property rights may apply to your situation. It's important to remember that whatever your work is, that it needs to be a work of authorship. Sometimes that's described as a work of creative expression. So if you've, I don't know, I'm trying to think of a good example. If your work is the peanut butter sandwich that you made for lunch, that may not be a creative expression. Maybe there's some way that it would be, but that's one of those borderline things. An alphabetic arrangement of names is not a creative expression. That's one that's been decided in the case law, like the telephone book is not necessarily a creative expression. Now, there might be something creative or expressive in the way that the list of names is arranged on the page, or the way the pages are formatted, but an alphabetical list in itself is not a creative expression. And then, as we mentioned a moment ago, it has to be fixed. So for transitory things like performances, they're not protected by copyright until they're captured somewhere and fixed, so that someone could go back and make another copy of them or use them again. And we talked about trademarks. Those rights pertain to any word, term, name, symbol. Think of colors too. Colors can be trademarks. Like, I don't know, I associate the color pink with T-Mobile for some reason. And there's other phrases, like just do it, is associated with Nike, which in connection with certain goods and services can identify a single source of those goods or services. All right. So that's some background on commonly used intellectual property rights to inform options. And so now here's what you can do with them. Let's say you've seen an infringing work, there's an unauthorized use you're concerned about. Well, depending on where it is and what it is, here's some of the things that I do when clients come to me and say, we need your help with an infringer. So online takedown, that's just sort of a colloquial term that I've heard and used to refer to any number of tools, usually in the form of a web form, like an online form you can fill out, to notify an internet service provider of some unauthorized use of intellectual property rights. And a commonly used one is the Amazon's IP enforcement tool. Maybe some people have experience with that. But Etsy has a similar reporting form. eBay has a reporting form. I've used those myself from time to time on behalf of clients, but clients do them on their own sometimes. And so that's kind of a go-to if the infringing activity is online. All the Google services have an online IP infringement reporting form, like Google Search, Google Drive, Google Cloud. If you find a web shop that's infringing your IP, like your copyright, and it's hosted by a Google service, then there's probably a way to submit a reporting form through that Google service. So that's a lot of the big service providers. Shopify is another one. I don't have to go through all the names, but a lot of the big e-commerce service providers have built-in intellectual property violation reporting forms. And the reason for that is they don't want to be liable themselves for aiding and abetting, for indirectly infringing someone's rights by knowing about it and then not doing anything about it. So that's their tool to sort of help you help them by not allowing the unauthorized activity to continue using their service. So, but online takedowns aren't any good if you want to get paid, right? It'll only make someone stop. And so another option to consider, and these aren't exclusive, you can do both. You can take down someone's web page and then say, you owe me because you were using this and I made you stop, but you also need to pay for the time that you were using my work. So a licensing offer can take a variety of forms. It's easier to make a licensing offer if you are already in the business of licensing your work. It's a lot harder to make a licensing offer if you have to do it bespoke every time you encounter an infringer. And we'll get into this more later, I think. But one very practical question is, how are you going to accept payment? Let's say you tell someone that they need to pay you for your unauthorized use of your work, and they miraculously say, "Oh, you're right. Gosh, I'm so sorry." Are they going to write you a personal check? Are they going to pay you by credit card? And it can be very helpful if you're thinking about licensing your works to people who want permission, and then to people who have used them without permission, to have some sort of streamlined, I don't know if a web shop is the way to put it, but a service where you can just include a link in your email or whatever letter communication you send to people. It says, hey, here's my fee, click here to pay. And just like any other really commercial activity where you're accepting payments, the easier you make it to accept payment, the more often people will pay. So I think that's something well attended to if you don't already have a mechanism in place for streamlining licensing. Which gets us to bullet point 3 here, the licensing and payment platform. I don't help people set this up, but artists who come to me are sort of in different stages of their career, and the ones who have invested some attention into setting up a licensing or payment platform where it's easy for people to pay. They can select what kind of license they want. Is this a license for a single use? Is it a license for online? And if so, what are some of the restrictions, like only in connection with one website for 1 year? So the scope of the license, the duration of the license, the nature of the use, you can tick all those boxes, and then there's a price, and then they pay. Those are solutions, I think, that are out there for artists who are licensing their works, and I think it's well worth looking at, both for developing your own business, but when it comes to getting paid for unauthorized use, it really helps there too. And I'll have more to say on why in just a minute. The next bullet point is an enforcement or takedown platform. This is kind of I don't know if any of you have heard of Redpoints or CoreSearch. These are like brand protection platforms that do not only brand protection, but also will load your images into their database and search by image search online. And this is pretty sophisticated software. So it's doing image matching, it's doing word matching. And there's built into these platforms sort of automated cease and desist letters or automated use through like an API, an automated programming interface on the big e-commerce sites to submit on your behalf those IP violation forms. So the web form you might go to on Amazon, well, these takedown platforms have on the back end a programming interface where they'll submit that form for you once you authorize it. And so really streamline the process of taking down materials. It's super effective if you're dealing with the tidal wave of violations. And this happens sometimes. This is when I get called sometimes. If a rights owner has 1,000 uses of their work online, they don't, it's really crippling their business. Everyone's buying from these infringers and not from the authorized source of the goods or services. And so having a software platform that can do the image matching, do the takedowns, do it faster than a human can be very effective.
This is really good, Elliot, because one of the questions that came in was about like, well, the onus is on you to seek this out, right? Before you can really pursue restitution in any way. And so it sounds like what you're saying is that there are services that don't require that you're keeping your eye out, but they're keeping an eye out for you.
Yeah, that's a great question. And I love thinking about that because there's a lot of room for creativity in figuring out how to solve that problem. The image matching software and the word matching has its limitations. So you sort of get what you pay for. Um, one free image matching service is called Pixie, Pixsy. And I'm not endorsing any of the platforms that I mentioned here. I've had good and bad experiences with almost all of them. But Pixie's free, and it's for visual artists. Often photographers use it, and it has some of this built-in enforcement and takedown, so you can sort of go through a chart of the infringements that it finds online, and it does it automatically. Like it churns in the background. You don't have to pay any attention to it, and then at the end of the month, it says, "Look, we found." However many it is, 300 uses of your work online. 100 of them might be junk. It's not actually your work. 100 of them might be, people you want to use your work, like bloggers who are talking about you, which is great. So you don't want to take them down. But then 100, the other third might be people who shouldn't be using your work without your permission. And you can just click the enforce button. So that seems really easy on your part. But some of the downsides are, when you click enforce, what happens? Do you actually end up getting paid? And I don't have the answer to that question. But what happens on the back end is the details where the devil is in terms of, are you hiring a law firm to send that letter? I think the first level of escalation is sort of an automated letter. And I don't know what the rate of return is on that, but it's not much attention on your part, and maybe you get paid, I don't know, 10% of the time, 20% of the time. So that's one approach. And then if it has to get escalated, then at that point you're probably hiring a real person. Pixie would intermediate that and manage it for you, but then they take a cut as well. The other downside to the automated image matching or word searching way of finding infringements is that there's no, well, now I'm talking about it, there's two more downsides. So there's no prioritization, right? So it might come back with 100 hits and you have to decide which ones matter. And that requires some attention. Right? Some of those are going to be people you don't want to take down. And so if you just automatically click all of them, you'll piss a lot of people off because some of them were your friends and you didn't realize it until you got them a strike on Amazon or did something that really hurt their business by reporting them for infringement when they thought they were doing you a favor. So you really have to pay attention to those. The other downside is that they can't catch everything because the web is growing faster than it can be crawled. And so, go back to the Pixie example. Pixie's churning, crawling, looking for infringing uses of your stuff. but they're not going to find everything. They can't, and they might not even find the most important things to find. Some of the, I think it was called infringement.report, or another tool I looked at for a while. I'm forgetting the name of it. There's a few other free tools out there where you can upload your images. And here's 1,000 images, files of my creative work. Just go out and find it on the internet, and find unauthorized uses of these, and it'll crawl. But some of those tools won't even look at Amazon, or won't even look at certain e-commerce portions of the web, or if they do, are very selective. They don't go into all the different product listings on those sites because there's too many. The amount of CPU processing power to run the comparison for each page, each product listing against each of your images is so high that they just can't keep up. And I don't know what the number is, it might be 100,000 new Amazon product listings a day, whatever it is, I don't know. So that's another issue. So to bring it back to the original question that Celia offered from the group, how do you identify infringements? One of the most effective ways I've seen, even though the software is great, is paying attention to your customers. So the ones that probably matter the most to your business are the ones that your customers report to you. So someone says, hey, I found this ad on Instagram. It looks like yours. Is this you? That's one you should pay attention to. Or someone, submits a warranty or a return claim. Says, I bought this from here, but I didn't like it, so please give me a refund. And it's not yours, right? They bought it from someone else who's, selling knockoffs. So, everyone has limited resources to deal with unauthorized use. I definitely advocate, prioritizing communications from customers when trying to decide which unauthorized uses to focus on. Which brings us to a fifth bullet on this slide, which is licensing and enforcement. So a program has a little bit more of a human touch in my mind than a platform. And so I sort of combined bullets 3 and 4 into bullet 5 here to talk about a licensing and enforcement program. And I've administered these sometimes, and other people do too. The idea behind a program is it's a little bit more bespoke. You might have an agent who's willing to manage this for you, or a licensing manager who's willing to manage it, or an attorney who works, on a fixed fee or a contingent fee. Or maybe you do it yourself if the scope is small enough. But what a program for licensing enforcement would encompass is, having a payment plan and a form of communication in place to send out demands for licensing payments to unauthorized users. And in connection with that, having a form of communication in place for taking down unauthorized uses. So that's the enforcement piece and the licensing piece. And then using those together, you start having a more streamlined program for stopping unauthorized use and getting paid for it at the same time. So a licensing and enforcement program is really meant to refer to your own development of licensing and enforcement communications that works for you. Because each artist and each kind of creative work sort of has its own enforcement problems. And so figuring out the right balance of tools and activities that suits your business situation is really something that only you can fully figure out, or you in combination with your business advisors. All right, and then the last 3 bullets on here we'll sort of skip through. These are attorney actions. People sometimes try to send cease and desist letters on their own, and I think it's actually less effective than sending a licensing offer, because the infringer is going to go talk to an attorney 9 times out of 10. And the other 1 time out of 10, they're going to completely ignore it. They're certainly not going to pay you. they may stop. But if they get an attorney involved and you have a lot of back and forth, it's expensive and it's not going to get you paid. So, of all of the items on this list, if you want to get paid, number 2, the licensing offer combined with some sort of stick, like number 1, or sending a nastygram to someone saying, hey, this is mine, you need to stop. I think it's probably the best value. But it depends on what the infringing use is. So let's get into some case examples here, because sometimes you need a bigger stick depending on who's using your work. So just had a couple slides here showing examples of the reporting forms on different platforms. These forms also change every couple of years, so these may be outdated, but that's kind of what they look like. All right. So I was thinking about how to talk about specific examples because that's where these tools and intellectual property rights sort of come to life. And what I've done here is I've got a prompt on the screen. So our first one is the Moo Moo mug. It's going to help me remember what to talk about and hopefully help you remember what we talked about. The Moo Moo mug is not a real thing, but it's going to help me remember a real case that I worked on where I don't want to divulge any client details, but I can remember generally the structure of what happened. So the Moo Moo mug is a product with a unique configuration. It's got the face of a cow on a mug. It's a ceramic work of art. And the designer of the Moo Moo mug owns the copyright in the Moo Moo mug just by virtue of having designed it herself. And she actually got a design patent on the Moo Moo mug too, because she was really thinking about enforcing her rights and might take off someday and be a big thing. So, but business isn't so good. She sells like 10 Moo Moo mugs a month over the course of a few years. Doesn't seem like she's ever going to make back the money she spent on getting a design patent. But then a newscaster on CNN shows up with a Moo Moo mug at the 6 o'clock news. It's like, this Moo Moo mug is amazing. Everyone should get one, and here's the nightly news. And so over the next weekend, she sells 10,000 Moo Moo mugs. It's crazy. She doesn't know what to do. And so she's working on filling orders. She's ramping up production. And then, of course, the weekend after that, there's 10,000 knockoffs available online. And so what does she do? Well, I had a chance to work on this case, which was like the Moo Moo mug. And what we found was a lot of the competing sales, so sales that were being diverted from genuine Moo Moo mugs to knockoffs, were happening online. And so we looked first at how can we leverage these online reporting tools and just get them gone so that when people go to look for Moo Moo mugs, they go to the right place. And the design patent was no good. Like none of the online platforms would enforce the design patent. There wasn't a form to fill out design patent infringement. That's changed since then. So the online platforms, some of them are better, some of them aren't, but some of them will now do that, but not all of them. So what ended up being most effective was the fact that she took pictures of her Moo Moo mug and posted them on her website to try to promote the sale of the product. Now, those weren't inherently very valuable. It's just marketing collateral. But when the cheap knockoffs ramped up their web shops, they just copied the pictures, right? So every single one was infringing her pictures by using them. And so the fastest way to get them offline was to allege copyright infringement. Not the copyright in the mug itself, but just in the photograph of the mug. It worked great. We got a lot of things down, and life was good. Well, the Moo Moo mug infringers got smart and took their own pictures of their knockoff mug. And so then we couldn't use copyright anymore. And this is sort of the evolution of violations of her artwork. So at that point, we thought, well, how are they're still diverting customers from the genuine Moo Moo mug to the fake Moo Moo mug by using the word Moo Moo mug. Well, that sounds like a trademark issue because it's that word that people are searching for when they go out and search because they heard about it on the news, they heard about it from a friend, they saw it on social media, they want to go buy one, and that's the phrase they use. And so this is a trademark issue. Well, she hadn't registered a trademark. She owned a trademark because trademark rights arise from use. But if you want to assert intellectual property rights through a web form, so we're going back to that online takedown tool, you need a registration. So you can sue in court based on unregistered trademark rights. But if you want relief through an online form recognized by an e-commerce platform, they mostly only recognize registered trademark rights. And so this is one of those things where I'll note for our audience that something you can do in advance, if you have a brand that is valuable to you, and you see other people using that here and there, go ahead and register it. It takes about a year these days to get a trademark registration approved with the US Patent and Trademark Office. And so, filing that application sooner rather than later will help you be prepared when the time comes to have a registration number. We'll get to some details about trademark registration down the road. But that only not gets you access to online enforcement tools. It gets you access to the enhanced remedies that come with the trademark registration. So if someone infringes a registered mark, and you've put a notice of your trademark registration by using the circle R in some places where you're using your mark, that can help your claim, enhance your claim for additional damages, recovery of attorney's fees, and that kind of thing. All right, so back to the Moo Moo mug. It took a little while, but we got a registration for the Moo Moo mug. And once we did, we were able to take down a lot more infringing products online by using the trademark rights. And then the online infringers had their own images. Then they started using their own brands. It wasn't going to be Moo Moo mug anymore. It was just something else. And that was great. Now we're starting to get closer to not necessarily genuine, but fairer competition. People are selling the same product, but they're not using her images. They're not using her name. They're just making the exact same product and selling it under a different name. But she has the design patent. And here's where the design patent comes in handy. It's sort of down the road a little while. Things have stabilized a little bit in terms of sales. A lot of people know who she is. She can be found exclusively by the name Moo Moo Mug online. And now if she wants to go after bigger infringers using her design patent, then she can hire an attorney to send a cease and desist letter. She can do those more complex things that you can do with a design patent. All right, so that's that example. Let's do another one. Oh, one more thing. So design patents, even though it wasn't useful right away here, are good for the long term for a couple of reasons. If you are a product designer, or if your artwork is in sculpture or in sort of like the configuration of a thing, so sculpture or like design on the surface of a product or packaging, design patents are useful because it locks in the exclusive right to that design for 14 years, or maybe it's 15. And then at the end of that time period, you can extend the exclusive right by applying for a trade dress registration. And trade dress is like a trademark, but it has to do with the configuration of the product. And it's essentially like getting a trademark on the shape of something. And you can think of maybe some unique shapes, like the classic glass Coke bottle is sort of an example that people use sometimes, where it's a unique look, And, originally there was no copyright protection in that shape. But over time, it grew to be exclusively associated with Coca-Cola. And so it's now like a trademark. It's indicative of a single source of goods or services. And that's referred to as trade dress because it's the product configuration. It's not a mark. It's not a word mark or a phrase. So, and you can register trade dress with the U.S. Patent and Trademark Office in the same way you can a trademark. You just have to show that you've been exclusively using it for a certain period of time and that people associate that shape or that configuration of the product with you exclusively. So that's sort of a long-term strategy. If you have a design that's particularly valuable, then you can combine, sort of link together design, patent, and trademark rights in that way. All right, how are we doing on time? We are running out of time. All right, I'll move on and do these a little bit more
Quick
quickly.
question though,
Please.
are business or product logos considered trade dress, or is it like a trademark?
Yeah, logo would generally be a mark.
Okay,
Yeah, so trade dress is reserved for three-dimensional objects.
thank you.
Yep. So Magnus Magus, I just made up this name. I think it means great magician in Latin, but it's been a while since I studied Latin. If you, the point of this though is I've had a couple of situations where folks were clothing designers and had their clothing copied by others. In which case it's very hard to get intellectual property rights in clothing. There's some forms of clothing that can be protected by copyright if they're like unique, kind of at the level of a sculpture kind of creative. But the most effective thing that we ended up being able to use in the clothing context was the trademark, because in these cases the client was developing their own line of clothing, and so that was associated with the brand. And when other people were infringing or using their work without permission, they would invariably use that brand as well, because that was what drew customers. And so registering the trademark and enforcing the trademark ended up being the most effective way to protect the client's intellectual property in their line of clothing. So maybe a little counterintuitive, because if you think of yourself as a clothing designer, an artist in that sense, you might not automatically think of your trademark being an important piece of your intellectual property arsenal. But in my experience, that can very much be the case. All right, so photography. I want to talk about a slightly different kind of violation here. So I had a client once who came to us who was a photographer and took a picture of someone famous with their permission. They had been hired to provide photography services for this person who was sort of an influencer and was going to use the photograph for a limited purpose. And so the photographer granted a license to the person who is Dr. Fame in our example. And Dr. Fame paid them a licensing fee and then used the photograph for a limited purpose, whatever it was, promoting some, maybe it was like a nonprofit organization or some cause that Dr. Fame was interested in supporting. And so that was fine. That was all, good, clean use of intellectual property. And the artist, in this case, the photographer, was paid. Well, what happened years later was that somehow, whether Dr. Fame shared the photograph or someone took it online, went online and found it, a big clothing company who was also using Dr. Fame as a sponsor, like a paid sponsor and influencer, took that photograph and used it in promoting their goods that were sold in high-end retail stores across the country, across North America. And so photographer says, I took that photograph and licensed it for one use. Now it's being used in 30,000 different places without my permission. And in that context, online takedown isn't going to take the photograph out of retail stores across North America, nor is a licensing offer going to get you paid because the the big clothing brand who's selling in luxury retail across North America isn't really going to give the time of day to an email from an artist. And so in this particular case, what was critical was that the photograph, the copyright in the photograph had been registered. So you can get damages for copyright infringement, but it's only going to be based on your typical licensing fee. So in this case, had the photographer gone to the retail stores or the clothing company and said, pay me my licensing fee of whatever it was that he was originally paid by Dr. Fame, he maybe would have gotten, I don't know what it was, maybe $500 for the use. That's something for the photographer's trouble, but in this case, the use is so much beyond what was originally authorized. It doesn't seem right that the clothing store should get away with that. So in this case, it was, I think, worthwhile, and it's just something to consider based on the situations you find yourself in, to bring in an attorney. And in this context, whether someone works on a contingent fee or some sort of, budgeted rate, so the costs don't outstrip the value of the claim too quickly. There's lots of different ways to structure that. But in this case, we were able to negotiate after sending a cease and desist letter, after doing some case law research and saying, look, here's all these different cases where similar things happened and the company was found liable. And here's the statute where, since our copyright was registered before you started using the photograph, we have a claim for what's called statutory damages, which is up to $30,000 per infringed work for non-willful violations. But for willful violations where you knew or should have known that the work you were using, the photograph, was used without permission, that's up to $150,000. And so at that point, you're talking real money and you have somebody to negotiate with, which take this moment to make a plug for registering your copyrights. If you're a visual artist, you can really enhance the value of your claim against folks who are making unauthorized use of your works by registering your copyrights even before you publish them. There's more provisions from the Copyright Office to register groups of unpublished works. So instead of doing them one at a time, submitting groups of works for registration when they're unpublished and when they're published, which is also a reason to do it, to apply for registration sort of as part of your creative process. All right, so there's the photographer. One more, and then we'll skip to Q&A. So movies. This particular example, let's say you create a movie featuring turtles, a sea turtle, for the Sea Turtle Preservation Society to create awareness of habitat preservation in a tropical location that you love to visit. But the turtle population there is suffering from habitat degradation. So you make this nice video, you do it for free, you own the copyright, and then someone makes a viral meme on social media using a clip from your sea turtle video, and then there's all this merch that starts showing up. So people are merchandising the meme, and it's a still shot. It incorporates a still shot from your video. People are selling it all over the internet, and you think, gosh, I wish I could get something from this because this is my creative work and it's being used all over social media, and then it's being used to make money. There's these like web shops, and who knows, maybe the tropical location itself has now got little vendors set up with booths everywhere selling t-shirts with your sea turtle pictures on it. So in this case, you've got the copyright. I would start with the copyright in your video, which encompasses the exclusive right to display publicly still shots from the movie. Registration would really help if you have registered your work before it's being used by others. So that's a key piece. You have to register before the unauthorized use begins or within 3 months of publication. in order to have access to statutory damages and attorney's fees in a copyright claim. You might think about what you want, like the meme isn't so bad. So do you really care about people using your C-Turtle video on Instagram in a meme? Maybe you do. Maybe that's offensive to you. And so you try to take those all down and submit reporting violations to Instagram. But maybe that also helps out your sea turtle cause. People are getting more aware of the sea turtle habitat preservation issue through the meme. So that's not a legal question. That's a what do you care about as an artist kind of question. In this particular situation, what we ended up doing, it wasn't sea turtles. I just made that up. Was a lot of online enforcement. We ended up connecting the client with a licensing and enforcement software platform because it was on Alibaba, it was on DHgate, like it's an international problem at this point, right? It's being sold everywhere. And the capacity of any one human being or even a team of human beings to track all those things down and make them stop was pretty impossible. So having some software on your side ended up being a worthwhile investment for this client. And the client was also starting to sell its own merchandise. So in this case, the monetization strategy was, we're going to sell this stuff ourselves. We're going to sell the sea turtle merchandise. And that's how we're going to monetize, because people want to buy it now. So we'll try to get those sales ourselves, set up our own web shop, our own authorized source of these goods, and try to shut the unauthorized sources down. I actually prefer that strategy as being slightly more reliable and more in your control if you can manage it from a business perspective than the strategy of allowing the unauthorized use to continue and then trying to shake people down for money on the back end. And that's just from experience, seeing what works and what doesn't work. Sometimes you can recover money by allowing unauthorized use and then pursuing damages, but it usually takes considerable more effort than if you were actually using intellectual property yourself to sell similar goods. All right, so strategy-wise, I'm going to go through these pretty quickly. We've talked about these in a haphazard way, but I just wanted to list them to provide another maybe way of organizing it in my brain, in your mind. When your work is used without permission, think about what you want. That should be a first key thing in how you respond. Do you want to let this continue? Do you want to make it stop? Do you want to get paid or some combination? Is it offensive to you? Do you like what's happening and just want some recognition? And then think about what rights you have. Is this a place where my copyrights will help me? My exclusive rights as an owner of the copyright, is that what's being violated? Or is it my exclusive rights as a trademark owner? We haven't talked about patents and trade secrets because I think they sort of are less frequently applicable in these situations. So those are the two main ones to think about. And then think about who's gonna manage this situation. Do I have what it takes to communicate about licensing and enforcement? And is this a one-off, or am I going to have to do this every day for the rest of my life? And then think about before it happens, what are some proactive steps to strengthen your rights? Registration of copyrights and trademarks can be really helpful. Let's talk about notice and marking next. So my little animation here, copyright symbol is coming up in the lower left. I'll just play that again for grins and giggles. There you go. The elements of a copyright notice are the circle C, and then your name, and then the year. So if you can put that on your creative work, that provides notice, and it also provides a mechanism for getting Digital Millennium Copyright Act damages. So we haven't talked about that yet, but that is another statute that relates to copyrighted works that if someone removes the copyright management information from a creative work, for instance, they take what's in the lower left on the screen and put it on the lower right without the copyright notice, that in itself is two violations. It's a violation of your exclusive right to make derivative works, as a copyright owner, and it's a violation by removing the copyright information from your work. And that second act triggers additional statutory damages and additional liability under the copyright laws. So it's just
Can you
another way. Go ahead.
can you talk a little bit about the date? Like, is that the creation date? Do you have to have a date range if it's a notice that you're posting for multiple works? Like, how does the date come into play?
Yeah, that's a great question. So the date should be the date of creation. And it certainly could be also the date of publication, which could be a range if there's multiple works that are being referenced with the notice. Certainly having a range is entirely appropriate. The reason for the date is so that people know when it expires. In theory, copyrights expire after the author's life plus 70 years, or if it's owned by a company, not by the author anymore, but it's been transferred to a company, it could be a different number of years. In practice, the date doesn't matter that much because who's going to be doing this 70 years from now? At that point, there's going to be a new version out, or you're not going to care. It'll be your heirs or managers of your literary estate's problem. And so, but yeah, a good rule of thumb for the year is just the creation date or a range of publication dates, if there is a range. So for trademarks, you can mark with the TM if your mark is unregistered. So that actually gets you some of the benefits of notice, even if you haven't put in the investment of registering your trademark. You can use the superscript TM for unregistered marks. And then the circle R when your mark is registered. You don't have to put a name, you don't have to put a date when you're doing trademark marking. You just put that in the upper right corner after your logo or mark. You don't have to do it in every single place. I mean, it's, from a lawyer's perspective, it's always great if there's like markings of intellectual property rights everywhere. So everywhere you see the logo or everywhere you see the trademark, it's got all these markings on it. From an artist's perspective, that's a nightmare, right? You just want to have your logo without all these extra things around it. So be, I guess, thoughtful is the best guidance. I think try to balance. The whole purpose is that people know that this is an intellectual property right and shouldn't use it. So if you never provide notice or marking of your trademark rights, then people will not think it's a trademark. They might just think it's, a word that you made up that anybody could use. And so it's helpful to use it enough to educate your customers that you consider that to be your proprietary trademark, whether or not it's registered. And then the formula for copyright we mentioned is to include the author's name if the author is the owner, or if the author's transferred their rights to someone else, the owner's name, and then the year of publication or the year of creation. Okay, registration, we'll cover this briefly. For copyright, there's all these things that you should include in a copyright application. If you go onto the US Copyright Office materials, you can find a lot of guidance on how to apply for copyright. This is just a summary. This was off the top of my head. I didn't go through the Copyright Office list. These are just some of the kinds of information that can be required when you apply to register a copyright. The transfer statement piece is really just about who owns it. So if you don't own it anymore because you were the author, but then it was a work made for hire or you sold it to someone, that's really what would go in the transfer statement. You might say I was working for someone else, and so this was a work made for hire, or I sold it to someone else pursuant to a contract, and so the transfer statement might just say it was assigned. Publication doesn't occur when you put something online. This is just a weird wrinkle. because people don't get a copy of it. They can view it, it's displayed, but its copies aren't distributed. And so publication refers to distribution of copies, whether they're electronic copies or physical copies. That's when publication occurs. So if you email someone a file or post a file for download online, that can be publication. But if you are simply putting something up on your own website and you maintain control of it, doesn't necessarily mean it's been published. All right. Trademark registration, you need to identify the mark and then what goods and services are offered in association with your mark. So for example, it might be fine art prints or oil paintings or classes. Maybe you're offering classes in connection with your mark because you're training other artists. You don't have to list all the goods and services. You can just pick one. Every additional class of goods and services takes an additional fee. So sometimes folks like to be judicious about how many goods and services they identify in their application. But the scope of protection is for as against any related goods and services. So if you register your mark for oil paintings, that should be effective, depending on how many other similar marks are out there, but it should be effective against identical marks for, say, watercolor paintings. You don't have to be, your registration isn't necessarily limited to the goods and services that you identify. Okay, and then this is US trademarks. You can also apply to register trademarks under the law of each state. Like if you're in Oregon, you can register your trademark with the state of Oregon. The fees and information required may be slightly different. And then just maybe a final note about enforcement. I mentioned this earlier, but every artist's work is different in the way that it's used without permission is different. And so I think the artist or the business owner who's managing sort of the business aspect of the artwork is the person who should really think about what this program or plan should look like. How are you going to identify unauthorized uses? How are you going to assess them in terms of what intellectual property rights are going to be our best allies in stopping this unauthorized use and in monetizing it? And then who's going to be the person who does the communicating? Who's going to reach out to the unauthorized user and say, you owe us a licensing fee, or you need to stop? And then how are you going to receive payment? This is really a nuts and bolts issue, but I imagine it's just as hard for artists as it is for attorneys. How are you going to get paid? And the easier you make it to get paid, the more often it's going to happen. And then what kind of plan are you going to have to escalate? Do you have an attorney you can call? Do you have the OVLA clinic that you can call? Do you have maybe an online takedown that you could use? That can sometimes be an escalation. You give them a licensing offer first and say, look, you can use this so long as you pay for it. And if they don't do that, you take them down. That's another escalation plan. So each plan should be tailored to your business, to your priorities, and to the situation you're dealing with. The note about software and attorneys is sometimes software can be helpful for each of these steps. Sometimes attorneys can be helpful for each of these steps. But the value proposition is yours to decide. There's lots of other things we haven't talked about. There's the Copyright Claims Board, there's federal court litigation, there's customs, there's all kinds of fun things that attorneys can do for IP rights owners that we can talk about in the Q&A if we have time. I just put this slide in here about the Copyright Claims Board, since some people might be curious about it. We'll consider that reference materials and turn to Q&A.
Perfect. Okay, I have a few questions that have come in that I can start with, and then if folks have other questions, feel free to put it into the chat and we can cover those as well. The first question was, what happens if the author changes their legal name, both in the sense of, I guess, registration, but also just even if an image has been floating around and has been kind of credited to someone and suddenly it's someone else by name?
Yeah, I don't think it invalidates the rights. We'll start with that. And wherever the work is registered, it could be useful to file some sort of ownership update. Like in the Copyright Office, I think you can correct information in a registration. There's a form. And you would probably need to provide, like you do when, say, you change the title to your car or change the title to your house, provide a document that shows it's still you. But I don't think that would be a barrier to enforcement necessarily. You know, if you had registered a work or provided notice to a work, I wouldn't hold back from enforcing that work just because the notice is in a different name. If you're still the same person, if there's actual continuity of ownership, then the recording of ownership can lag the actual ownership information. So makes
Okay,
sense.
cool.
Yeah.
Thank you. Okay, the next question is about basically the copyright mark itself and placement. You know, if you're an illustrator or visual artist and you don't want to really put the mark on the original image, what are your best options? I mean, watermarks are, I guess, one topic, and then I don't know, proximity to the work in where it's displayed. I'm just curious, what are all the different methods that are acceptable and enforceable?
Yeah, that's a good question. So I don't think I can give legal advice on this call, but in general, the most, you know, whatever you can do is better than doing nothing. So proximity is good. Like if you take trying to think of a sculpture or something, right? Maybe you'd put it on a lower portion of the sculpture itself, somewhere where it's not very visible. Or
Yeah, or even like a photograph or an illustration, things that I think about that are really common, especially on the internet where it's easy to steal things, are two-dimensional art.
yeah, sometimes with photographs you can put it in the electronic file. So
Mhm.
I think some cameras even do this nowadays.
Yeah,
There's
in the metadata.
right, exactly. Yeah,
Hmm.
that can be a way to do it. Um,
But it doesn't necessarily have to be on the image in order for it to be enforceable, as long as you can show that it's your ownership in some way.
that's right. So notice is not required for enforcement. It's just one of those proactive steps you can do to strengthen your remedies.
Hmm.
That's right. You know, if you
Okay.
can show that someone should have known better because there was a notice on that, it's just, you know, maybe additional
All the
access
better.
damages,
Yeah.
right?
Okay. Perfect. And then someone was making sure that we understood correctly that trade dress is really only three-dimensional objects and doesn't apply on like illustration, graphic, surface design, where it might be more copyright and maybe to some degree a design patent, as you were saying.
Yeah, so there's some overlap there. So like copyright can cover three-dimensional things as well. A lampshade or a unique body of a lamp could be protected by copyright as well as by design patent and trade dress all at the same time.
Hmm.
So these aren't necessarily buckets that have to be, you know, have clear lines between them. They overlap. In terms of, you know, a design on the surface of something, uh, like say, for instance, you have a unique sort of mosaic pattern that goes on the surface of something. And that's what you want to protect, not the thing itself, just the
The surface design itself, yeah.
surface design. Yeah. I think that could potentially be both registered as a copyright and protected with trade dress. I'm not sure though. You know, I think copyright at least would have to, you know, trade dress has to also serve as the indicator of source or origin or affiliation, right? So until it's recognized as sort of serving a branding function,
Mm.
you wouldn't have trade dress rights. Um, Design patents can protect surfaces. So I do think design patent protection could overlap with copyright protection in that particular example.
is this like a cost management strategy that some artists need to sort of go through and just be like, what am I willing to proactively pay for protection? Are some of these things like very expensive?
Yeah, yeah, I think that's right. So design patents, we didn't talk about much, but to register a design patent, you have to pay the fees for examination and you have to wait. So the examination period for design patent is probably, I don't know what it is now, a couple of years. And then the fees, even if you're an individual person, a small, I think they call it is a small business applicant, you get your fees reduced down to 25% of what the standard fees are, but it's still going to be a few $100s. And so, if you're doing that every time you have a new work, it could be cost prohibitive, not to mention the time and attention it takes. The drawings also have to, so a design patent is the legal rights are defined by the drawings, and so there's a lot of rules around how the drawings are formatted. Um, Usually, in the law firm environment where I work, we have patent illustrators we work with who know the rules and we communicate with regularly about following the rules, who can convert CAD drawings to patent drawings. So if you have a CAD drawing, that's great, but it won't necessarily get you what you should have in terms of patent scope because every single line becomes part of your, claimed design. And if some of those lines aren't important, then you're narrowing the scope of your rights more than you should. Because if the person who uses your work without permission cuts out some of those lines, well, they may not be infringing then. And so there's just some extra steps and costs associated with tailoring the design patent rights to a meaningful scope. So that's one reason we didn't spend as much time on that. But certainly, like if you talk about Apple v. Samsung, that was a design patent case that involved the two-dimensional display, sort of the arrangement of the Apple iPhone Surface. And so those rights can be very valuable if you're developing a valuable product where the design is going to be a big part of what consumers find interesting about your work.
Cool. Okay, but just to kind of circle back on the trade dress really quick, like that's more in that brand space where trade dress would be three-dimensional and maybe like surface design on objects, whereas trademark would be more that two-dimensional logo mark, that sort of thing.
Yep.
Perfect.
Yep.
Okay, the last question I'm seeing here right now is kind of about using software to prevent screen grabs as a method of trying to get ahead of some of this.
Mm-hmm.
So ASPS software, what has been your kind of experience or perception of the effectiveness of that?
Yeah, it's a good question. So I haven't dialogued with any rights owners about how effective it's been at preventing infringement.
Mhm.
Can't speak to that directly. Indirectly, it probably cuts off some portion of the people who would steal your work, but not the more sophisticated ones. So yeah, you might give yourself some insulation or some, it's like maybe raising the height of your fence a little bit, but it's not quite the same as putting barbed wire on top of it. It discourages some violations, but I don't think protects you entirely.
Makes sense.
Yeah.
Okay, well, that was our last question. So if there's any last things you wanted to share, we have a few more minutes. Otherwise, we can wrap up and send folks on their way.
Super. Yeah, I can talk for just a minute about the Copyright Claims Board, since I included that information here. This was created in 2020 by an act of Congress, and and sort of went into effect a couple of years after that. People refer to it as a small claims court for copyright infringement. So it's the kind of thing that might be of interest to artists, people who want to monetize their copyright, but aren't going to go to litigation. It's got limited damages, right? So up to $30,000 in actual or statutory damages, and it's limited to $15,000 per work infringed. And you can't get an award of an attorney's fees if the other side is, being unreasonable or has acted in bad faith. But both parties have to agree to it. So if you bring a claim in the Copyright Claims Board, you may find yourself in federal court all of a sudden if the other side doesn't agree to it. And you can also bring DMCA claims. So that stands for Digital Millennium Copyright Act. We talked briefly about removing copyright information when somebody takes your work, and also removes that copyright symbol being a separate claim. Those can be included in Copyright Claims Board claims. So a colleague of mine at Stoll Rives did kind of a study year over year of what kind of claims were being brought in the Copyright Claims Board to see whether artists were using it as a small claims court. And the answer so far has been not really. It's not been a place that's been easy for artists to use to monetize their own unauthorized uses of their work. It's still predominantly attorneys who are showing up there, and even bigger companies who are trying to use it just as another piece of their enforcement portfolio. So I'm a little bit discouraged about the value of the Copyright Claims Board, but that's not to say that, if some of you have had different experiences or just want to give it a try, I'd certainly be interested to hear about those experiences. And I'd love to be shown wrong, love to be shown that it's of greater value than it appears to be so far.
Okay, well, perfect. Thank you so much, Elliot. This was really helpful. And thanks everyone for joining.